Welcome, everyone. I'm Terry Mottershead, the Executive Director of the Centre for Legal Innovation at the College of Law, and delighted to welcome you back to our AI for Legal series. Could not be more excited about this session and being able to introduce to you Joel Borolski. Joel, as you can see on the page in front of you, is a principal at Edge International, but also hangs out with the academics occasionally as a senior fellow of the University of Melbourne. And of course, I'm sure you've read his pieces, for example, with the Australian Financial Review. Always fabulous, always insightful, and always educational. Joel is going to be chatting with us today about generative AI and your firm's strategy and business model. And as I say, very much looking forward to that. I'm going to disappear off the screen, but I'll be sitting here in the background. But I most particularly want to hand you over to our amazing presenter today, Joel. Just a delight to welcome you back to the Centre and to this series. Over to you.
Thank you, Terry, and hi, everyone. Great to be here today. And over the past year, there's probably been 1,000 webinars, seminars, conferences on generative AI, but I suspect this is probably the first one that will start out with a picture of a billabong. And I'd like to use this billabong to reflect as imagine that billabong is the mid to large commercial firms in Australia. And what I really would love to do today is to ask the question, is Gen AI a pebble, a rock, or a massive boulder that's thrown into that billabong? And the reason why it's useful to think about that metaphor is to actually go back and recognize that we need to tread very cautiously in this area of Gen AI, because there have been numerous times in the past where new things have come up, be it new law or Big Four or artificial intelligence, first gen, blockchain, the internet, even going back to dictaphones and email and so on, which people have said are going to completely disrupt the legal market. And really, the upshot is that they've really just been pebbles. The firms have just merely sort of embraced those changes, adopted them, and they've been added to productivity. In my view, and somewhat might be controversial, really, there's only been over the last 30 years in Australia, from a big law perspective, really only three sort of larger rocks, which is one is the growth of in-house, and that's been a slow moving rock. The nationalisation of the professions, where many firms integrated their partnerships at a national level. And about 12, 13, 14 years ago was the entry of global law firms into the Australian market. And to be honest, I don't think there has been a massive boulder. And the question is Gen AI a massive boulder that firms need to react to and respond to? That question around disruption is an interesting one, and there was a great article published in the Sloan Management Review just a short while ago, where Julian Birkinshaw is a strategy professor at the London Business School, and David Lansfield is a senior partner at PwC. They asked this question: how come professional services have seemed to have dodged disruption? And they put forward three perspectives, but they all relate to the actual model, the producer, leader, owner model that happens within law firms, where you have most of the partners on the tools as producers. They're also leaders and managers in the firm, as well as owners. And that model has allowed the senior people to be very close to the market, very attuned to client needs. Most of the innovations have been sourced to solve a client problem. They haven't sort of come or been, there hasn't been a separate R&D department allocated with the job of, coming up with some fancy new product. The innovations that have emerged have come through solving a due diligence problem or discovery problem or document review. It's come from the practice itself. And because you have the owners there, there's generally a caution to, not just, embracing the new flashy toy and being a little bit skeptical. And those are the three reasons that they posited as to why firms avoided disruption. I have some other views. I actually think that most of the innovations that have happened, particularly on the technology side, have been more supplementary to the core service. So they've helped with communication to clients or in some of the documentation work or those areas. They're not actually been substitutes. They haven't been substitutes for legal work. And again, some of the new innovations have been a bit clunky. They've been expensive or difficult to train. People need, specialist skills to make them work. And the last aspect why I think legal has avoided disruption is that legal is dynamic, the legal world, that you're working within a judicial system that's quite conservative, but also ever-changing regulation. The business world has become much more complex through globalization, new technology. And so the thing's not static. And so the firms have adjusted and responded to that complexity. And that again has helped them avoid disruption. It's not a static thing. And so it's important to have these questions in mind. And really today, my purpose is to explain where and how Gen AI might be disruptive, might be a big boulder, and really give you a framework to approach this idea, this thinking that you can start to work on right now. So how do I take these thoughts and put it into practice in my own firm? So that's my objective for today, is to where and how is this Gen AI going to have an impact, and how do I take this forward? And so the first part is talking about actually why are we thinking about Gen AI as a boulder? And there's a few important things about the technology that are worthy of note. And the first is that it is a natural language input and output. So people can write a question or a query or command in English, and they get an English answer. They don't need to have keyword searching or understand Boolean architecture, or there's just that natural language aspect. It generates new content. It's not like Google, which just creates existing content and just gives you a list of websites. It actually generates and describes and produces new content, and often it is quite creative. It's relatively easy to use and learn. There are some limitations and some skills to pick up, but by and large, anyone sort of can get on it. And actually, one of the most profound aspects of all of this is that potentially it's going to be on everyone's desktop. So Microsoft, the big players, particularly Microsoft with their Office 365 applications, are looking to have Copilot on everyone's screen. So people don't need to pop out of their existing environment and go into a new application, or go out into a new world. They can use the technology, and everyone, both on the client side and the provider side, can access the technology. This Gen AI thing, from what I've read and observed, it's also not solving one problem. It doesn't just solve, for example, document review, or it's not just solving narrow topics around in knowledge management, or in summarizing large text. It actually does lots of different things. It's quite broad and diffusive in its application. So far, it's in terms of the early generation technologies, and we are still at the early generation. It seems to be quite smart. It's aced the bar exam, and the ChatGPT-4 got in the top 10%. And there seems to be an enormous amount of hype in and around this particular topic, and part of that is also being fueled by the fact that there's lots of money being thrown at it by some very large players and some of the biggest companies in the world, but also to offering a system that's accessible to all. It's not just available to big firms, but to small firms as a software as a service. What can AI do in legal is then the next question. And again, there's been lots of seminars put on by CLI and others talking about all these different applications or areas of use. And to give you a flavor of that, I thought, if you can indulge me, I will take you through perhaps the most advanced AI application in the legal specific domain, which is being produced and being developed by a company called Casetext, which they built off the OpenAI ChatGPT-4 language tool. And it'll perhaps give you a first-hand view of what we're actually talking about. For those who have seen this product demonstration, I apologize, just indulge me for a few minutes. But I think it is important to bring everyone up to sort of a common level of understanding, so we can then talk about some of those strategic implications and understand why we might be saying some of the things we are. So the first is to support in the litigation space. Imagine you needed to prepare a legal research memorandum. And so this is an example, and please note this is from a US product. But what it's saying, the quest here, is there an administrative procedure for suing an employer for discrimination in Massachusetts? What this program does is then allows you to allocate the specific jurisdiction. So all the issues around in ChatGPT 3 and 4, where you're not sure which data sets it's using, here you can narrow the data sets and be quite specific as to where it's drawing its data from, ensure the accuracy and the quality of that original data source. So that kind of request might have taken a junior lawyer, say, a day, but the system can then comes back with an answer, a short answer, and then a full one-page analysis. But it then actually then also provides the various cases that it used to draw on its answer, and the statutes and the regulations. And indeed, you can then click further into the specific cases in terms of the judgments and then the regulations as well. And so again, the idea here is that the technology can be used to do that work of what perhaps a junior lawyer did in terms of preparing that research memo. It still obviously would need to be reviewed and checked as you would currently do by a senior lawyer. In the transactional space, this is a contract policy compliance issue. So what this can do, you can ask and ask the application, check for compliance or non-compliance in the contracts that you load up, whether they comply with the policy. So in this, for example, any anti-assignment provisions that could be mutual or should be authorized assignment in a merger, acquisition, or other change of control. So that's the policy. You upload the various contracts, and then the technology comes back with where is there a difference or non-compliance with that policy, but then redlines the contract to say, well, this is how it should be changed, potentially changed to make it compliant. So it can actually assess whether there's compliance with those policies. You could search a database, and a database could be a set of contracts. Question, as an example, if a pandemic disrupted a supply chain, would the manufacturer still be liable? And again, this is not going into the internet. This is going to a set of contracts or any kind of database that you pointed to. It could be your own internal contracts. It could be a client's set of contracts. So you narrow the set. And again, indeed, it draws out a short answer to that question, and then the source data. Similarly, review documents. A document could be thousands of emails. An example here, are there examples of someone making false statements, anyone joking around? And the system can give some indication, yes, no, I'm not sure, insufficient data, or no in relation to that analysis. Similarly, to extract contract data, what are the conditions for modification, how much notice is required for termination, and gets a list of maybe there's 100 contracts in a contract database, and actually extracts that data and looks at those provisions. So it's all these activities that sort of grunt activities that could be done, that could be streamlined through the system. In terms of summaries, provide for a brief, detailed, or comprehensive summary of any document. Could be a journal article, could be a Royal Commission report, and then it provides that summary. Market check, that looks for the most widely used contract clauses for particular applications. So who's responsible, typically responsible for the initial post-closing purchase price adjustment calculation, reviews all the recent contracts from your own firm, and then provides the right clause, or the most commonly used clause in that particular example. And then lastly, prepare for a deposition. And again, I represent the plaintiff. He's the wife in a divorce case. We're trying to find out where he might be hiding money or other assets, and it prepares the deposition with a detailed list of questions. Why am I spent the last 5 minutes talking about co-counsel? Well, and case text, it really does give that flavor of a legal specific example of using AI. So it goes to the heart of what lawyers do. It's not just writing poetry or helping with a general email or PowerPoint or an analysis of a spreadsheet, which many of us, I'm sure, have seen demos. to me, it starts to get a feel for actually this application doing sort of legal work, or sort of frontline legal work. The other thing that's important is that actually Casetext, the company, has actually acquired this CoCounsel and acquired the company which has developed CoCounsel. That happened about a month ago for $650 million US. And Thomson Reuters have a partnership with Microsoft to make sure Copilot is in Word and Teams and every application that everyone uses. So with that backdrop, what's the future? And really there are, right at this point, there's still a range of questions around aspects of quality, around IP, around privacy, security. There's uncertainty around different suppliers and players. There's also a raft of issues around ethics, governance, and regulations, which I'm not going to go to. But there's just, we're just not sure. And so when we're not sure, the best approach is to perhaps look at different scenarios and say, well, what potentially could the outcomes be, and what might we do if that was the scenario, if that was the reality, the alternative, the future reality that we're faced with. So we move to the second part now, which is just quickly deep diving into three market scenarios. And in developing these scenarios, I thought it'd be useful to, one, use two things. The first is to use this idea of exchange theory. And that is, if you look on the left of that screen, this is the idea that in any exchange between a firm and its client, value is created. And total value is defined as the difference between what the client gets, or their perceived benefit, or their gain, minus the firm's costs. What costs were incurred to deliver those benefits? Price just splits the value. Who gets what share? So client value is the difference between benefits and price, and firm value or margin is price minus costs. So we'll come back to that, because I'm going to use that to illustrate how these different scenarios might play out. The second aspect of developing these scenarios is to look at the impact of what happened around 25 years ago when computer-aided design emerged in the architecture profession. It's not a perfect analogy, but it's an interesting one, because it does actually show the impact of a technology that was quite close to what actual architects did. So it was close to the core. It wasn't just about communication or engagement with clients. And we'll use that as a case study to reflect on the examples. So scenario one is no road, is in the sense that this Gen AI is really just another pebble. It doesn't really deliver some of the problems that it currently has around hallucinations and IP and privacy and security issues can't really be addressed, or the courts are completely don't trust it. The regulation comes in and makes it very limited, and it helps at the margins. It helps on some of those things that people are already using it for. So really that is one scenario. It's a realistic scenario that this is just turns out to be another pebble. And what happens in the value exchange? Nothing, really. In the scheme of things, the sort of status quo. Scenario two is fascinating. Is really the high road. And if we go to that analogy of CAD in the world of architecture, CAD has enabled buildings to be built and structures to be built and designed that could have never been designed with pen and paper. It's enabled a whole raft of new solutions, new opportunities, most amazing creative products and deliverables that could never have been done with the old technology. Not only has sort of opened up a whole new window of design opportunities and new solutions, but the client experience is just so much richer. People can get a visualization, a 3D mock-up of their building before it's built. Internally, different architects can collaborate on the same project. The architects can also collaborate much more actively through CAD, through the technology, with engineers, with surveyors, with builders. So it's transformed the client experience, as well as offered a whole raft of new opportunities. And in a sense, if we play out the high road, the total value created is expanded by all these additional new benefits. There are new tools, products, and package solutions. There's the automation of some of that grunt work. The workforce is retrained to use the new technology. There's some new technologists, but ultimately, with a much greater share of a much bigger pie, both parties find a way to share that pie. The price is a combination of fixed fees, hourly rates for less scopable work, and technology use fees. But by and large, because you've got a much bigger pie to share, both parties can enjoy the benefits of those. And again, if you just pick one area, say the M&A field, and you're doing work on a regular basis for a private equity fund, if you start to use your mind, how could Gen AI increase that total pie and make it the high road? And there's a raft of ideas, just some initial ideas in terms of creating more value for private equity clients in terms of using the technology. It's also worth noting that the technology can have other sort of high road benefits. Firstly, by streamlining some of the grunt work in some areas, costs will come down. Improved the productivity will make some of the work more affordable, more accessible, and indeed that in turn may create demand. And people like Richard Susskind talk a lot about Gen AI, addressing this huge latent demand for legal services. This area of where you productivity improving demand is actually called the Jevons paradox, if people want to know. But if you want another example of that, imagine you live in a small country town, and the road from your town to the major city is full of potholes, and suddenly they fix all the potholes, and not only is it great for you as a local to use that road now because it's nice and smooth, but everyone else starts to use that road because you're just removing all those potholes, and that's that same idea. The same thought is that with AI technology in the reg tech space, actually will find more issues and raise more legal needs and increase demand. The whole area of AI particularly is opening a new area of work for law firms in terms of advice in IP and privacy and governance and M&A. So it's a new rich vein of legal work. And there's heaps of studies talking about the impact of AI on improved productivity across the market. And also it's a nicer job, that some of that grunt work, that boring bits that people generally don't like doing, well, the technology can actually potentially make the job more interesting and more stimulating and the workload more sustainable. So there is that high road scenario. The alternative is the low road, where we actually, if we go back to the architecture example, we note that actually CAD technology in some instances removed that picture on the left of your screen and replaced it with the one on your right. And generally there were fewer draftspeople, especially for projects with replication. So by replication, I mean, so if you imagine you're building a multi-story office tower where each level is the same, or you just copy and paste the next level, or a development where the houses are very similar design in a new residential development facility. And so in some cases, not so much in the bespoke area, clearly there was a need for fewer of those draftspeople. And indeed, one reflection of that is that over time, the price paid for drawings as a percentage of construction cost fell from 67% for hand-drawn to around 2 to 3% for CAD. Now, the total production costs, construction costs have gone up, so it's a bigger number, but the relative share of the value has gone to clients. And that's the point, is that potentially, where you, particularly if you have a time-based business model, if clients say, well, actually, we would like to enjoy the benefits of any productivity gain, and what we will do is that we'll ask you to just charge by time, and we will only pay for the time of your workers. And so in a sense, the average price drops. Clients enjoy a greater share of the total value. And if that starts out at the top end of the market with large buyers, be it the big banks and corporations, insurance companies, government, then that ultimately will cascade further down the market and pricing will drop overall. You might say, well, surely firms will just not charge by the hour. Well, we've been saying that for a long time, and hourly rates are still the most dominant form of pricing. And many of the very large buyers, for example, in the state of Victoria, they've just negotiated a new panel arrangement based on 6 years of discounted hourly rates. So the hourly rate model is still the dominant form of how firms are compared, and procurement drives using the hourly rate model. And if you then model that back into a firm, imagine you used to have a team of 7. You now, because all that grunt work is now done through Microsoft 365 Copilot, you now have a team of 4, still reviewing a lot of that work. But ultimately, the firms typically make the biggest profit contribution comes from 2 to 7 PQE lawyers who are fully utilized. There's still a leverage model, and the modeling that we've done shows that with a, say, 25% improvement in productivity, especially at the junior level, you could see a 15 to 30% drop in team profit contribution, particularly if you're still working on an hourly rate basis. So it's quite significant in terms of the low road, in terms of the reduced profit impact. In addition, there are other factors that might actually make the low road even worse. And in some cases, where you have expert buyers and informed buyers who in-house lawyers, they will most likely have access to very similar technology and be quite proficient in using it. They potentially might use that technology to do the initial drafting themselves and then hand it back to their external law firms to validate, to do the final steps, to essentially take on the risk of whatever that contract, whatever that document, whatever that process is about. The impact of that for the firms is that there will just be less demand overall, but indeed their professional indemnity risks skyrocket, and costs around that will increase significantly. And this is called demand-side disruption, and the risks here are quite significant. Similarly, one aspect of Gen AI might be to predict case outcomes, and so you can imagine where you have natural or serial litigators like banks, insurance companies, construction companies, perhaps to use the history of similar disputes over a period of time, can use the technology to say, well, we'll settle these disputes and for a particular quantum, and they will perhaps do that without law firm involvement. And still, I would imagine some very complex cases would still proceed to litigation, and still some precedent-setting cases would go. But again, overall demand would diminish quite significantly under this scenario. The other aspects to this is that one stream of work that many firms have is the sort of regulatory investigations market, and again, the technology can substitute in many of those areas as well. Another aspect of the low road is what we call adjacent disruption, where the platform that all the firms are working with is now, and the value is captured more and more by the platform provider. So the knowledge rests with companies like a LexisNexis or a Thomson Reuters. The AI tools and technology, the license fees go up, and in a sense they form a duopoly. I mean, there may be other players, but the point is that in terms of the value captured in the legal supply chain, the platform providers may leverage that market position, charge higher fees, and also become direct and indirect competitors by offering packaged solutions to firms, but also clearly to the end clients, and be much more active players in the market. So we present the low road, and so we get to this position of, well, which scenario is most likely, and it's interesting. I think people like a one-handed consultant in the sense they don't particularly like people who always argue on the one hand this and the other hand that. they say, well, what's your position? So if you had to get me off the fence as to sort of what's the most likely picture, and it is very hard at the moment because there are so many uncertainties, is that I actually think that the outcome and likely outcome is what I've called many roads. And and if we just start out by actually going back to our case study of what's happened in computer-aided design, what we noted, and I interviewed a number of architects and people who work in that space to prepare for today. It's clear that some of those early adopters of CAD got some kind of short-term competitive advantage over those who were laggards. But it certainly accelerated the commoditization of less complex projects and designs. That replication point I made earlier, it didn't really disrupt any of the bespoke or complex firms. It just, instead of drawing on a piece of paper, they draw on a screen, and didn't have a material impact on how they worked or how many people they had. But certainly in terms of the collaboration, the communication, and working together, it did accelerate and facilitate globalization. But the many road scenario is really based on this idea that really I just think there are too many forces at play to form a binary conclusion. So what I mean by that is, Gen AI is going to be terrible for lawyers, or Gen AI is going to be wonderful for lawyers, or to me, it actually, the forces around client buying behavior, buying power, the leverage model, the pricing model, the regulatory constraints and other constraints to access the technology. All of these are relevant forces, and they're second and third order forces. So things that a benefit might result in more demand. So there are lots of moving parts here. And so I just think having a blanket binary conclusion is wrong. And you need to actually look at it in a much more nuanced way, practice by practice, and look at the features and dimensions of each practice, the competitive context and drivers in each practice, and then work out what's the likely disruptive threat. And again, for different firms, that also the perspective might be different. For some firms, they're looking to protect their current patch and they're very happy with the current arrangements. Other firms, are looking for disruption and looking to be pioneers and move into spaces. So again, depending on what your perspective is, but you need to take this nuanced approach, and it's an important part of actually starting to do the homework now, so that you're better prepared for if the technology does emerge, and scenario one, which is the no road, is actually not. It's really a combination of 2 and 3. One doesn't happen. And so to be helpful, and that's my mantra as a consultant, I thought, well, if I was in a position of running a firm, how might I grapple with this? And so what I'm positing here is a new framework, an analysis framework based around 4 variables. And the idea is to then analyze each practice on these variables. This is the first time I presented this, and I haven't seen anything like this presented anywhere else. I might have these variables wrong, and it's good to challenge that, but it's a starting point. And the starting point is firstly to look at Gen AI as what is the upside? Where, can it actually generate major new client benefits? Can it transform the client experience? Can we all become Frank Gehry architects, and design things that weren't thought of before? And I think in some practices that the technology does lend itself to that, and others which are maybe stream leasing or some other commodity areas, perhaps it's less of an opportunity. I might have picked a bad example, but it's just I think there are some areas which are more where the opportunity is greater and those which are less. The second key variable is that of the substitution potential, particularly of junior lawyers. So does it substitute for the high cost labor? Does it automate? Does it reduce those steps? And particularly if it's a dominant model of pricing, if you're a price taker within a particular model and it's hourly rates, the less of a substitution potential, the better for incumbent law firms. But if you can value price and you're in that position with your clients, or in that area, or that's how your firm has sought to compete, or you can move the market that way, in a sense, you have more potential to capture the value that we talked about before. The third dimension refers to client power, which is a function of their spend, their expertise as buyers, their legal capacity, and their procurement strategy. So again, if you're doing private client work, say you're doing estate planning and litigation, again, the relative power of a private client in that capacity is far less than say, providing support for a general insurance company providing claims litigation, for example, where they would be expert buyers with deep internal resources. Generally speaking, the more power clients have, the worse it is for incumbent law firms. And again, this is taking the perspective of a protective incumbent rather than a disruptor. And the last aspect to this, and this is really more going to the pace of disruption and the change, the more constraints there are in terms of the regulatory framework, in terms of the court processes that are involved in different areas, or the cost of the adoption. Again, the greater those constraints, perhaps the slower the rate of disruption, and therefore the ability for firms to adapt and move with that, and therefore perhaps slightly lower risk because it's not just something that's been dropped on you. And so the framework suggests that we should look then at what's the best case, and you need to take your perspective. So in the case of if you're an incumbent seeking to protect your position, the best case is high value growth, low substitution, client power low, and constraints high. And client power also is a function, for example, the bottom example in competition law, if you, for example, have a high-end competition law practice, my best guess is that the value growth opportunity is sort of medium low. Substitution, because those firms are highly specialized teams with reasonably sort of medium to low leverage, the substitution potential isn't that great through Gen AI. Client power is low because of that specialist knowledge and expertise, and the constraints are medium. Really, that's the upshot of that would probably be a green. I wouldn't be having too many sleepless nights. And similarly, though, in a general insurance litigation, where the value growth opportunity is low, substitution high, client power very high, constraints medium and high, so that could be slow, but that's potentially a red. And so the idea here is that my view is that to take this forward at this time, given what we know and don't know, is to do this practice analysis and to firstly challenge the variables. Feel free to add a fifth one, which might be the latent demand growth. You can add other variables, but I thought these four were the most meaningful in terms of the activities that you can work on right now. And so, what can you do? What can you do or start to work on in your firms now? And I think going back to that. The opening research that I mentioned about the producer owner leader model, staying close to clients and focused on their problems, that's going to be an enduring benefit of just being very clear what's going on and how clients are thinking about it and working on that. That's not going to go away. But it is important that I think, given that this technology, I think is different, even wearing my skeptical hat on and knowing that most the other bits and the other disruptors of the past have been mostly small, little pebbles rather than rocks or boulders. I do think this technology is different, and it really is worth tracking its development and use cases, particularly in legal. And don't get too sidetracked by the all the doom and gloom stories that come out, or the hallucination stories. Those are real. I'm not dismissing those, but it sort of potentially takes you away from the potential application in these areas, because it really is, from what I'm reading, it really is a technology at its infancy. It's almost like imagine your iPhone. It's an iPhone generation, iPhone 3 in its development. It's come onto the market and it's got lots of problems, and there are a whole range of issues to address, and people are being quite dismissive because of those problems, but perhaps missing the big picture. So I think it's important to stay on top of it, but not get too paranoid. I think because it's so public and people are using the technology in their private lives to actually control the narrative as a firm, avoid the panic, raise the awareness, share the practice analysis that we'll talk about in a minute further, but soften the ground if there are new developments. And then, as we talked about, adapt and use the Gen AI practice framework to develop a game plan, practice by practice, and you need to do that and to work out actually what we might do then to avoid being dumped, or learn how to surf and surf better than others. And then by looking at each practice, we can also see, well, actually there's some common themes. For example, how we price is going to be a critical variable in going forward. What's our pricing muscle like? How good are we at communicating and capturing value? Because if we can actually get better at that, we can capture a bigger share of that value that is created in that first scenario, but also perhaps mitigate some of the downside in the negative scenario. So this analysis will also reveal some of those additional capabilities that you perhaps need to enhance in your firm. And I actually do think pricing, the analysis suggests that pricing domain is perhaps one of the most significant. The second obviously relates to how you develop talent and skills, and develop and perhaps also shift and redirect some of your learning and development programs for people to be better at embracing their technology, become more digitally literate, to do the prompt engineering and so on. And again, and similarly, in some areas, there may be opportunities around, in common areas, around new products and new processes that can be developed. But it is working at that level to understand what's going forward. And then similarly, for those where there's common opportunities, we see the analysis will reveal where and how you could possibly be an early winner. How could you take the technology and look to enhance the client experience, and look to offer new products and solutions, and to get that value equation much higher. So today I've taken you through quite quickly, but hopefully you've got a feel for where and how Gen AI could be a boulder, and taking you through in quite some detail that co-counsel product demo, and to give you a feel of how it could apply and address some of the issues in relation to quality and to the databases that are being used. But then also to talk about, I've got there three market scenarios, but really the fourth scenario is my view that really the way forward is many roads. I think it will impact different practices in different ways, and you need a much more nuanced approach to look at where the upside is big and where there's significant downside risk as well, and start doing that now, because you'd be much better off prepared and have control the narrative, particularly with your partners and the rest of the firm. Because coming back to my first proposition, is Gen AI a pebble, a rock, or a massive boulder? In my view, I think it's all of the above. I think that in some areas it's going to be a non-starter and have minimal impact, but in others it's going to be quite profound and a massive boulder in your billabong. Terry, I'm happy to answer some questions at this point.
Absolutely. And Joel, I'm just going to kind of bring up a few for you here, just to start with a couple of, I guess, definitions, and then jump into a few more meatier questions. First one here is, can you explain more what you mean by practice approach?
Okay, so most firms would have practice teams or practice areas. So they'll typically have, in a full service firm, they'll have a team focused, say, on employment law, one on tax, one on litigation and disputes, one on mergers and acquisitions, and so on. So each of those are different sort of practice areas, and so it's about looking at this technology practice by practice. So it's by each of those areas. Now, some firms may be a boutique firm and just offer one practice. They might be a family law practice, and they just have one. But many firms, and I'm presuming here, many of the firms on the call are more full service firms, and indeed would have a range of practice areas, and with servicing different types of clients as well, ranging from big corporates and government, insurance in some cases, and through to private clients as well in some firms.
Absolutely, thank you. But another quick one on this: when you were talking about incumbent firms, what are kind of the criteria or features that you typically think of in relation to them?
Well, if you look down the list of the top 50 firms in Australia, that's the incumbent firms. And again, I mean, those firms have, the list is fairly stable. Yes, I know some of at the top end, there's been a few of those firms have tied up with international firms, but essentially the Australian partnerships are pretty much the same as they were beforehand. And people have talked about, massive changes in aggregation and mergers of those firms, and very mature market. We see this aggregation. Well, it hasn't happened. You go to the list of the top 20 firms in Australia 15 years ago, and you look at that list now, and it's a very similar list with a few name changes, but essentially it's the same people, and the firm sizes haven't changed dramatically. I mean, there's been one or two exceptions. I mean, probably H.W. Ebsworth is probably the biggest exception, being the largest partnership, and that wasn't there 15 years ago, certainly. But by and large, we those incumbent firms go down to the top 20, top 50, are those established firms with established teams and clients, and that's what I mean by incumbents. And the theory goes, I mean, the whole disruption theory is that when new technology comes along, say, for example, people often use the example of a digital technology. You had an incumbent like Kodak, which used, film imagery. Digital photography came along, and the incumbent didn't change or couldn't adapt. It sort of tried, or sometimes initially dismissed the change, and ultimately the incumbent went out of business because it wasn't able to adapt to the new change, or just got amalgamated in new technology in some way. But it lost a lot of its power and competitive position.
Just kind of thinking on the examples that you've seen at the moment, and understanding that you have made the point that a lot of this is still in its infancy. Have you seen any, and this is a question, have you seen any disruptor law firms or other legal service providers at this point that are using AI well? So I guess that would extend beyond the immediate generative AI focus.
Look, AI as a technology has been around for some time, and again, this is slightly getting out of my zone of expertise. I'm not a technologist, and I've just been reading a lot about it recently to get up to speed, because I think it has strategic implications, and I'm a strategy consultant and advisor. So yeah, the big firms have used AI for e-discovery, for document review, but my understanding is that technology is still quite clunky to get the data ready for it. It has to be pristine in terms of how the data is prepared for those applications, and it takes quite a bit of time to train people to use them, and there are quite a lot of limitations. You have to use keyword searching or Boolean architecture. There's a whole raft of things which sort of provide constraints and barriers to people actually using it in a substantive way. So many of the big firms will have teams that do that stuff. You also have AI in day-to-day tools. So Grammarly is an example where we often use that to assist with our writing, and Grammarly has AI capability. So we do use AI in those sort of day-to-day tasks and so on. But in terms of the general question, can I provide case studies? I can't, because I think we we're just nowhere near ready. Like the example of co-counsel, firstly, it's based down in America. We don't have an Australian-based version of that. And at the moment, there's still a raft of security issues. People don't want to put up any client data into the system. There's a whole lot of IP. There's a whole raft of other technical problems that firms have, there's been lots talked about, and the regulatory framework is not in place. So, I'm a bit sort of skeptical of new AI, amazing sort of case examples, because I think it's still quite new. Yeah. But as with most technology, the first generations are clunky and are buggy and have problems, but generally within a year or two, they seem to get them fixed, and those things are worked out, and people start to use them and trust them. So I'm suspecting, I may be wrong, that's what scenario one is the no road, that doesn't come to that, that they actually don't work those things out, but I think they will. But I can't provide more. That's why I used the co-counsel example, because it felt to me the closest to, actually, this is sort of stuff lawyers do and junior lawyers do, and that's why I thought it was most valuable to share today.
Yeah, absolutely. And I guess the other thing is that, and I don't know if you agree, but it seems to me that we're in a situation now where, rather than it being shiny in a promise, there's actually substance behind the fact that these things are not just emerging, as you say, but will continue to emerge. So
yeah, there's substance and there's some big money.
Absolutely.
So Casetext was bought, $665 million US. And you've got some big players, putting a lot of money behind this. And there's an old saying, follow the money.
Yes.
It's not always the case. Sometimes big players make mistakes. But it's doing some of that grunt work which firms have charged for in the past. But also, I don't just want to, and hopefully that message came through in my presentation, it's not just the doom and gloom stuff, it's also the upside. It's also the, building a bridge that could never been built before.
Yes.
And have a client experience or activities that truly add a lot more value and get that pie really expanded, which both parties can hopefully then share in. Yeah. So, there's really is upside potential here too, but I think it's practice by practice is to really look at it and work it out. Where is it going to be impact? It's not just all good news or all bad news. I think it has to be looked at a much more nuanced level.
Yeah, and being open to thinking differently too. I mean, that's one of the keys, I guess. But let me jump into another question here. Will all of this lead to greater consolidation in the law firm market? And if so, in what time frame? Is it 6 months, a year, 3 years, or is that just too hard to predict at this point?
Yeah. Look, you might suspect some consolidation in areas where there is perhaps more of a low road impact, and firms then need to share need to aggregate to get some scale and share costs, or share overhead and the cost of doing business, and share the cost of acquiring using the technology over a bigger volume of business. So you could suspect some consolidation in those volume areas. My general feeling is that it's going to be a little while. Like, I don't have any strong evidence to say that, but for sort of a couple of reasons. One is I think there is a conservatism, not only on there's a conservatism in the profession generally, and that's on the client side as well as on the courts, as well as the regulators, as well as the firms. So I think people will be treading quite slowly and carefully down this particular path. So I suspect that kind of consolidation will take a little bit of a while, but once it starts, just go back to the entry of global firms. People said, that might take 5 years to play. Well, that played out in like 2 years. That whole thing, and happened quite quickly. So I'm contradicting myself slightly, but my instinct is probably take a little while till it starts to any movement, and then once it does start to move, it'll go quite quick. is sort of my best guess at this point.
Yeah. There's a lot of questions here around pricing, so I'm going to try and consolidate them in the interest of time into one.
Yeah.
And they're around kind of with Gen AI infused or integrated into the equation. Does that actually mean, from a billable hour point of view, that the price should be higher, particularly at the moment, because you've got to check it a lot to make sure that it's okay, or should be lower because it's stripping out things? I've even heard it suggested that we should have a billable hour rate for Gen AI. And of course, we've also seen the discussion at the moment, which brings into all kinds of questions around professional responsibility, that you pay one price if it's generated by something like ChatGPT, but you pay a different price if it's thoroughly checked. And by the way, not advocating any of these, just simply reflecting the thoughts around this.
Look, it's a fact that
about this.
We could spend a long time. Look, the general view. Imagine you had an area where Gen AI had a high substitution impact, right? So it did. So you went from a team of 7 to a team of 4 plus co-pilots. Just let's take that as an example. I suspect that actually the hourly rates of your senior people will go up for two reasons. One is just the complexity of the work that they're doing, and two, because of the cost of their professional indemnity insurance will need to be recovered in some way. But the overall net cost to the client of a given quantum of work will reduce because you are substituting high cost labor for potentially a low cost technology. So that's my best guess, is that I think that rates for the senior people will go up in this particular model, and because there's still critical issues at stake, and people are willing to pay for good advice where there's complex work and there's lots at stake, and some of the other costs have also increased, but the net cost, in a sense, given the overall the overall resource brought to bear to solve a client problem, to prepare that contract, to settle that dispute, it will be less, and therefore there'll be a net lower price in that specific example. So, but it does vary, and again, we'll see a lot more creative pricing arrangements emerge as the technology evolves. But my advice is get prepared. Actually, start to think about that. Work out how you're going to capture value, or communicate and capture value in this new world.
Yeah, I mean, it could also be the end of the billable hour, to go back to your point, because we're redefining value with some of this as well, right?
Well, look, firstly, I think there's still going to be a lot of work or elements of work where it's very hard to scope, and I think our hourly rates have just proved to be quite enduring, where you have unscopable work. So I think there'll still be value there. Secondly, many of the big clients have shown a strong preference to keep using hourly rates. That's how they tender firms, ask firms to tender through hourly rates. So clients are quite entrenched around that model. So I'm not seeing that disappearing very, very quickly. But the integration of other alternative pricing arrangements, I think, will come into the mix.
Yeah, absolutely. Joel, tragically, we've come to the end of our time. And so I just wanted to thank you very much again for a fabulous presentation. Also thank everyone for attending. I hope that you enjoyed this. I know that we didn't get to all of the questions, and I'm sure there were many more that folks were thinking, but you know that Joel's on LinkedIn and you'll find him there and you can reach out to him. And I know, Joel, you're also open to folks doing that and to responding to them. So do please take advantage of that. You'll find him on LinkedIn. You'll find the centre there as well, and on a whole bunch of other social media. So thanks very much again, Joel. Lovely to see you again. Thank you, everyone, again for being here, and we'll see you next time.
Thank you. All the best.
Bye.